I'm Shannon Gunn Emery. Welcome back to Legal Eyes. Today, Gunn Law Group is going to be giving you its best tips and tricks for how to run and hopefully win your IRS. If you are from the United States and you're thinking, oh, thank goodness, there's a podcast to help me with my problems with the Internal Revenue Service, nope. For today, the IRS means Immediate Roadside Sanction. In fact, it will always mean that because there will never be an episode on Legal Eyes about the Americans' Internal Revenue Service. No, here it means Immediate Roadside Sanction, which is the modern-day equivalent in Alberta of an impaired driving offense or an alcohol-related driving offense. Now, despite the name of this podcast, Legal Eyes, I can't see my audience, and so sometimes I'm left guessing. Like today. Are you a do-it-yourselfer? You got a notice of administrative penalty, but you're also thinking you could defend yourself on this. Whether you made that decision because you are very courageous and confident in your arguments, and you don't see what a lawyer could do for you anyway, or you just don't have the means to retain counsel and could really use some coaching or assistance. If that is you, dear listener, this episode is definitely for you. Or maybe you're a lawyer or a law student faced with one of these for the first or second time and you find it overwhelming. We're here to help. Maybe you're a potential client wondering, what is that lawyer going to do for me anyway? You've heard these are really hard to win, so what arguments do work? Or maybe you don't have any impaired charge pending, you're not a lawyer or a student, you're just kind of morbidly curious about what could happen if you were in that situation. Whoever you are, consider yourself welcomed. Get all comfy because we are about to embark on a legal adventure. And of course, I have to warn you, this is not legal advice. Don't come to me and blame me that you lost your IRS, even if you did a fabulous job and you tried to use all the ideas that we brought up in this podcast. You could still lose your IRS. The law is literally changing every single day, which is why I am checking for new cases all the time. But I can't update this podcast, and I can't guarantee that one of the great arguments that I'm proposing hasn't been shot down in flames by the Court of King's Bench since recording. So you rely on this at your own peril. Don't come suing me after, because that would really not make me happy. And frankly, it would just be mean. Okay, the legal caveat out of the way. Fasten your seatbelt. Here we go. Our adventure starts with the issuance of the Notice of Administrative Penalty. You got stopped for impaired driving and you were given a ton of paperwork. Well, maybe not a ton, maybe just 3 pages. A seizure notice, an impound notice, and the Notice of Administrative Penalty that I refer to as the NAP. The most important of the 3, you guessed it, is the NAP. But that seizure notice can be helpful too, as I will explain in a moment. One of the first things you have to know is you only have 7 days to start this appeal, so do not wait. With your Notice of Administrative Penalty in hand, you go to the computer, type in Alberta Safe Roads, and dismiss all the ads, including ours, that comes up because you want the Government of Alberta's website page for Safe Roads. The URL should be something like https://www.alberta.ca Safe Roads Alberta. You should see a box called Enter Your Contravention Number, and there you are going to look for the contravention number on your Notice of Administrative Penalty. If you got a Notice of Administrative Penalty that has any red ink on it, you got the older one. So then you're looking for the A to O number, which is usually, I believe, at the top right-hand part of the page. If you got a black and white form, you got the newer Notice of Administrative Penalty, and it has a C to A number on it. When you type this into the contravention number box, you have to include the C, all the numbers and the A, or the A and all the numbers and the O, depending on what form you have, into the box. Otherwise, your contravention will not come up, and you won't be able to do anything. Press Search. And very annoyingly, you will find that you probably have to input the same information again. Now, please don't ask me why, because I didn't make up this silly system. I just have to work with it. Put it in again and hit Look Up. You will then be prompted to put in your last name and your date of birth, which you know those already, and then as well the occurrence time. That should be at the top of your sheet, whether it's red or it's black and white. Somewhere it says occurrence time. Type in that time and then press Search. Now, dear listener, do not be disappointed or discouraged if when you do all that, it gives you some error message or says you haven't done it right, and you've tried it again and you've tried it again, and it still comes out wrong. It's not that you're doing anything wrong, and it's not my fault either. This podcast hasn't steered you wrong so far. It probably is that the officer either misspelled your name, put in your date of birth wrong, or very possibly put in the wrong occurrence time. Remember how I said that the seizure notice might be useful? Well, here it is. You can get into the Notice of Administrative Penalty sometimes by going down the rabbit hole called Search for Your Seizure Notice, and then you can link up to the Notice of Administrative Penalty. Try that. Oh, didn't work, huh? Okay. In that case, you have to contact Safe Roads by email at this address, saferoads@gov.ab.ca. And you write something like, "Please help me. I have tried to get into the Safe Roads portal and I can't. I was stopped on this date at this place. Thank you for any assistance you can provide. Yours truly." Do not add that that is the date that you got the nap, because whether you actually got a nap or not can be an argument. Name, place, date. That's it. Maybe date of birth, but then that's really it. Then you wait to hear back. And to give them their due, they're pretty good at getting back to you with a correction or something that helps you to actually get in. If you can't get in within the 7 days, then you're going to have to make an application for a late review, which I'm not going to get into now because we have a lot of stuff to cover. But if you need help with that, contact one of the lawyers at Gunn Law Group and we would be happy to help. Assuming that you got in, the next stop on our legal adventure is a lovely spot called Contravention Overview. At this point, you should see a number of boxes. You'll see Pay Now, Request Time to Pay. Ignore those. Look for Request a Review and click there. And then a rather scary box pops up with a red flag and a little triangle of caution saying, "A review won't reduce fines or penalties. Do you wish to continue?" Click Yes. You will show them you are not easily intimidated. Next, a Terms and Conditions box will pop up. Don't worry about it. Just click on Proceed to Review Details. We're forging boldly on. First box asks representation type. Are you the recipient of the NAP, or are you a lawyer representing someone else or an agent representing someone else? Put in whatever it is you are. If you are a lawyer or an agent, make sure that you are aware of the consent to representation required. That's a form that you and the client have to sign. If you don't do it, you don't get the hearing. So make sure it's done and uploaded. But you have up until the day of the hearing to get it in. Under Review Method, choose Oral Hearing. That's going to cost you $150. In our office, we prefer oral hearing because we can still send in written submissions, but we also get to talk. And you probably have guessed by now, I like talking. But I mean, seriously, I like to explain what the arguments are to the adjudicator, and you never know, they might have questions that you can answer. Now, when you click on oral, another box is going to pop up asking, if you don't make it into the meeting, what do you want to have happen? Do you want to be deemed to have abandoned it? Or would you like the appeal to go through, but just on the basis of your written submissions? I always click the second so that it will not be abandoned, but of course I plan on being there, and I have always been there. You should be there too. Next, you will see a box called Grounds for Review. Type in that box that reasons will follow upon review of the disclosure. That way, you can send in your written submissions after you've had a chance to look at what's on the portal. And in almost any box where they allow you to write, type in that you want the video and audio recordings from the police vehicle, any other recordings that they made, all the notes and the reports from every officer involved or any other individuals involved. You won't get that, but at least you can say later in a judicial review that you asked for it. There's a useless and insulting box about interpretation. You can click yes or no if you plan on bringing an interpreter. Basically, they should just have something that says, we will not give you any more time than your allotted 30 minutes. We will not be providing an interpreter for you. It's up to you to cover the cost for your interpreter. Basically, we will do nothing for you. You're on your own. Click no, even if you need one. What's the point of clicking yes? Frankly, what is the point of that box at all? It's just there to make Shannon mad. It works every time. Next, you'll be asked for preferred contact information. Put in your email address or your assistant's email address. You can put in your client's email address if you're a lawyer or an agent, but beware, they're going to be the ones that get the decision, and they're going to be the ones then that get any updates or messages. So make sure whatever email address you put in is an email address that is being monitored responsibly. And now we're getting to the really exciting part where you push the blue button saying, proceed to schedule review. And it might be anticlimactic because you expect dates, but they might not give you any. Like today when we tried to schedule a hearing. They have to give you a date within 21 days of the day that you were given the notice of administrative penalty. But what do you do if they're not offering you any dates, let alone ones within that time frame? Don't panic. On that page, you will see a phone number. You should phone that number. It's 780-427-SAFE-7233. They also suggest that you can email at saferoads@gov.ab.ca, but really, in this case, phoning is best. And when you get them on the phone, explain, they're not offering me any dates on the portal. So someone there behind the magic curtain, like the Wizard of Oz, will bleep, 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 bleep. And all of a sudden you can press refresh, and voila, dates will appear almost like magic. Pick a date, and then a timer starts, and it will hold that date for, I believe it's about 10 minutes, and then click on Proceed to Payment Method. Get your credit card out, because you're going to need it. Once you've put all that in, there will be a little application summary that comes up. Check it all over, make sure it all is correct, and then, once you have approved it, another screen comes up that says, Application submitted. Congratulations! You made it through the first leg of our legal journey. Whoa there, don't leave the portal yet, though. There are some other places I want to show you, some other spots we need to explore. First, a little reminder. Once you've got the date, your written materials are due 2 clear days before the hearing. So say your hearing is on a Thursday, well, Wednesday, Tuesday, Monday is your deadline. But you have until midnight on Monday to get it in. In addition to the written submissions that you can send in, you can also upload photographs, you can upload other documents, scientific studies. You can also upload video. We've tried doing that, and it's kind of hit or miss if it'll work. As for the hearing itself, it is going to be a 30-minute hearing in front of a Safe Roads adjudicator. Whenever I do these things, I always prop up my phone where I can see it, and I have a 30-minute timer that I start as soon as the Safe Roads adjudicator has finished with their spiel about how they're independent, impartial, etc., etc. Be aware, there are some very obnoxious adjudicators out there who seem to think that the time starts when they start talking. No. Don't let them eat into your time. And if they say, you've got 5 minutes or whatever it is, you can correct them and say, no, according to my timer, I have 8 minutes and 20 seconds left. Stand up for yourself. I will add, though, that I have had some lovely adjudicators who have actually given me a little extra time, but you never know if you're going to get the diamond or the dud. Going back to the portal for a moment, because this will help you, now that you have a date fixed, your landing page should normally say Contravention Overview. This time I want you to go to Review Status and click on the View Review Details button. So now you will see a big blue button saying Join the Meeting Room, and there will be other spots that say Supporting Documents, Consent to Representation Form. This is where you upload your documents. This is also where, the day of the hearing, you're going to click on the blue button saying Join Meeting Room to get in front of that adjudicator. And make sure you have downloaded beforehand the WebEx app made by Cisco, otherwise you won't get into the meeting. If you have issues, make sure you take note of the phone number on that same page, because that will let you get into the meeting and you can participate by phone, which isn't a terrible option, considering that, yes, they do record these things, but only by audio. So if you're participating by phone, you're not really missing out on a lot. Just make sure that if you are participating by video and you are showing something to the adjudicator, describe it as if the adjudicator couldn't see it. Because if this has to go to a next level, you want to make sure that description is clear on the record. If you go to the very top of that screen, you're going to see there's a little button that says Back to Contravention Overview. Click on that button. Once you're there, scroll down to Contravention Details, and at that point you'll see your contravention number, that A to O or C to A number, highlighted in blue. Click on it. So if everything is going according to plan, you should be on a page called Contravention Details. This is where all the disclosure is, and this tells you what the case is you have to meet. Now, I do caution my clients, if you go onto the Safe Roads portal and you look at it, don't immediately conclude it's hopeless. I don't see anything. I blew over twice. There's nothing to work with here. You aren't looking at it at that point, until you finish this podcast perhaps, with legal eyes. It's just like if you gave me an x-ray. I don't have medical eyes. You could be healthy as a horse, or you could have every bone in your body broken. I wouldn't know the difference. Legal eyes. That's what I'm trying to help you develop in this episode today. The first step is going to be to ask yourself, have they complied, the police or the director, whoever this fictional thing is against you, have they complied with 4 pieces of legislation? The Traffic Safety Act, the Provincial Administrative Penalties Act, the Provincial Administrative Penalties Regulation, and the Safe Roads Alberta Regulation. These acts and regulations can be easily found on a wonderful website called CANLI, CANLII.org. CANLI is something that I think Canadians ought to be really proud of. The Federation of Law Societies created this database to cover all the cases and legislation from across Canada. Those cases, acts, regulations, articles, comments, etc. are all made available to the public online for free. CanLII is going to be your friend in this whole exercise. During the rest of this podcast, I'm going to be talking about some cases, and just so you know, those are all able to be found on CanLII, and just so that it doesn't get too boring, I'm going to put the citations for all of those cases at the end of this podcast. I will give you a warning when that's coming up so that you could go off and do something else if you'd like. However, if you are planning on trying to use this podcast as an assisting tool for you to develop your own argument, you will want to stay tuned. Let's just pause for a moment and take a quick visit to CanLII, because I want to make sure you understand how to use it. And for all the lawyers or students out there, if any of you are listening, you're going to be rolling your eyes going, I know how to use CanLII. But some of you listening may not, so please, let's all be patient with each other. If you know this already, it's the perfect opportunity to play solitaire while you're listening. Under Primary Law, click on Alberta. You should see a number of headings. One says Legislation, the other one says Courts, the other one says Boards and Tribunals. The two that I'm going to talk about today are Legislation and Boards and Tribunals. Under Legislation, click on Consolidated Statutes. That should take you to a page called Consolidated Statutes of Alberta, and then you're going to see the letters A to Z at the top. So when you want, for example, the Traffic Safety Act, you're going to go to T. When you want the Provincial Administrative Penalties Act, oh, you're so smart. Yes, you go to the letter P. Let's click the back button. And still under Legislation, this time if you click Regulations, you're going to see the same A to Z choices, but when you click on S for Safe Roads Alberta Regulation, lucky you, it's the first one you're going to see and you don't have to go any further. Finally, under Boards and Tribunals, if you scroll down to the very end of that list on the main Alberta page, you'll see that the last board mentioned, one might think, last and yes least, is Safe Roads Alberta. That's where you're going to go to get many of the cases that I'm going to be citing later. The section numbers that are most important for our purposes today are, under the Traffic Safety Act, Section 88.1, Sub 1, and for the Safe Roads Alberta Regulation, Section 2 and Section 4. Those sections of the Traffic Safety Act and the Safe Roads Alberta Regulation are going to cover the vast majority of the arguments that we're going to be discussing today. Starting with Section 2 of the Safe Roads Alberta Regulation, that one talks about disclosure. What does the Director of Safe Roads have to provide to you, and what can you do if they don't? So it clearly states the Director shall provide the following records to a recipient, which are a copy of the Notice of Administrative Penalty. So if you go on to the Safe Roads portal and you don't see your NAP there, you have an argument. The report of the officer who issued the Notice of Administrative Penalty. There is a great case called Dorn, again the citation will be at the end, where the Court of King's Bench, just as spoken for, said if you don't get the report of the officer, that is a big problem. Unfortunately, in the 17 cases that are cited on CanLII where counsel have invoked Dorn, only once has it been successful in quashing the NAP, and that was on the rehearing for Mr. Dorn. Basically, adjudicators will still find, regardless of what the King's Bench Justice said, anything is a report. The next document that you should be getting is if an approved screening device was used, you should get the expiry date of the last annual maintenance performed on the device, the date of the last calibration of the device and the expiry date of that calibration for the device. While there are other sections, and you'll see them when you look at Section 2 about other situations, those are the most important ones. By the way, if this is a drug-related impaired driving situation, please call me because those are fantastic. There are so many arguments to those, but they are complicated and way outside the scope of what I can do on this podcast today. Getting back to where we want to go, let's scroll down to Section 4. I apologize in advance, dear listener. Section 4 will give you a headache. It's going to make your eyes go buggy, and it's very annoying to read. And that is mainly because every subsection, and there are a million subsections, refer to various offenses under the Traffic Safety Act. For our purposes, you only need to know about E, F, and I. E is used if the basis for the contravention was impairment of the ability to drive. F is used if the basis for the contravention was operating a motor vehicle with a blood alcohol level over the legal limit, and I is for failures or refusals. So read those over carefully, think about what each one is saying, and think of them as separate requirements. Because for now, I'm going to leave the legislation alone, and I just want to talk about categories of arguments that you can use. And then once we've got those down, we're going to go back and take a look at that portal and see if we can see the disclosure differently with our new set of legal eyes. The following are the general categories of defenses that appear to have worked in front of Safe Roads adjudicators. The first category is what I call care or control or not driving. Bit of vocabulary here. Care or control is where there's no proof that the vehicle was actually moving, but normally in care or control cases, the person is found in an intoxicated state sitting in the seat normally occupied by the driver. The concern there is that the person could set the vehicle in motion, thereby possibly causing a danger to others. It's kind of like a preventative offense. So you haven't really done anything to cause a danger to anybody, but we think you might. And so we're going to stop you before you even contemplate it. In a case called Pigeon, adjudicator O'Meara found that the appellant, who was basically living out of his vehicle, had no intention of driving and quashed the nap. In another case called Burke, again it was adjudicator O'Meara, found that because the vehicle was inoperable, there was no danger to the public, and therefore he quashed the nap. Adjudicator Gregory also quashed a nap in a case called Auger, Auger, where the adjudicator said it was unfortunate that the appellant had interacted with the vehicle while impaired, so she found impairment, but she said she had no reason to disbelieve the applicant had planned to stay with his friend that night, and that there was no real risk that he was going to change his mind. A really fun one is Hunter. Now, in Hunter, the appellant's cousin drove while impaired, and then when stopped, gave Mr. Hunter's name to the officer. I'm guessing the family get-together at Christmas that year wasn't great. That got quashed. And if you think that's a one-off, no. In the case called Kumar, adjudicator Edmonds quashed a nap where the recipient of the nap and the real driver confirmed that it was the friend who had driven the vehicle and not the appellant. Keep in mind that even if someone is showing symptoms of impairment like slurring of speech or balance problems, smell of alcohol, etc., in order to use that as a basis to uphold a notice of administrative penalty, the symptoms of impairment have to be happening at the time of driving. If the driving took place earlier and then later the person's impaired, well, there's not a problem with that. And that was the situation in a case called Kyrgyzstan. I'm doing my best there. KRZYSZTAN. And frankly, there are many more cases like these on this issue, so take a look at CanLII if you want some more. But for now, I'm going to move on to the next subject. That is failure to advise of the right to a roadside appeal. Just so you know, the roadside appeal is normally, not always, but normally, the opportunity to blow into a second, different screening device at the roadside. So a person may have failed the screening device test the first time, and that was pursuant to a valid demand, where if they didn't comply, they could be charged under the criminal code. But this second one is a voluntary option to blow into a different screening device to see if you get a different result. And if the result shows a permissible blood alcohol content, the NAP is cancelled. Unfortunately, the written notice that they're supposed to give people about that information doesn't tell all that. It basically just says you could be charged criminally if you do provide this voluntary sample, so a lot of people don't. That's another fight for another day. For our purposes today, you just have to know if you did not blow into the second screening device, you may have an argument here. Or if they didn't advise you of the possibility of blowing into a second device, you may have a good argument. One situation we see come up fairly often is where police go straight to an impaired charge, they don't use the screening device at all, and then they don't give the person an option to blow into a device as their roadside appeal. They seem to think if they go straight to an impaired and they didn't use a screening device first, well, there's no need to provide a second. Wrong. Provost and Pearson are two examples of the many cases where that is an argument that has succeeded. In a fairly similar vein, in Lumley, the officer didn't give any information about the roadside appeal because he was dealing with a GDL driver. Apparently, in this officer's mind, GDL drivers have fewer rights than the rest of us. Keep in mind, dear listener, that ironically, the one allegation for which you do not get a roadside appeal is a failure or refusal to provide a breath sample in the first place. Now, I'll explain why I think that's ironic. First, I will concede. If it's a straight-out refusal, that means the person said no to will you provide a sample of breath into this screening device, then there's not really any point in providing him with a second or a third or a fourth. He's just probably going to say no to all of them. Poor male listeners out there right now. Am I referring to the appellant as a he all the time? It could be a she. It could be a they. Safe Roads is an equal opportunities punisher. Where I see the irony is that the Supreme Court of Canada, in a case called Goodwin, said that the purpose of the roadside appeal is to ensure that there isn't a problem with mouth alcohol, but there also isn't a problem with the device. Well, if you're not able to provide a breath sample into the device, and the issue doesn't seem to be with you, isn't it possible it could have been with the device? And isn't it possible that if you tried on a different device, you might be able to do it? Yeah, makes a lot of sense, doesn't it? And it makes zero sense that you don't get a roadside appeal with a failure or refusal. But, dear listener, like I said before, the law is always changing, and that is one that has to change. Moving on. Related to this issue, but not quite the same, are the cases where someone asked for a roadside appeal but did not get one. The cases in this category, I almost guarantee you, will surprise you, and they're very good. Remember how I said that the roadside appeal was about the opportunity to blow into a second, different device? Well, some officers think, blowing into the same device is pretty much the same thing. Adjudicators decided, no, it isn't. Thank God they did. In the cases of Smigelski, Smigelski, Charpentier, Charpentier, N-T-I-E-R, and Holsworth, H-O-L-S-W-O-R-T-H. The problem that you may encounter is proving that actually happened. Usually, you only win on that when the officer is stupid enough to say that they used the same device, or the client was smart enough to be recording. Sometimes there's a concern that the screening device used for the roadside appeal wasn't working. Well, you can see where that could be a good argument. Okay, you've failed the first one. Let's have you try blowing into this other one that appears not to be working or wasn't properly calibrated or maintained. Yes, that actually happened in the cases of Prystay, P-R-Y-S-T-A-Y, Ferguson, and Finn, a case involving radio frequency interference. How fun is that? And a particularly nasty case was Isidore. Poor Mr. Isidore requested an appeal, but the officer said no. It was too late. It was late because the officers had arrived hours after witnesses allegedly spotted the recipient driving. Thankfully, Adjudicator Williams was sensitive to the unfairness of the situation, and she quashed the nap. I'm often, as you know, critical of the Safe Roads regime, but in this podcast we're really celebrating those adjudicators who were sensitive to unfair situations and tried to make things better. And my gut actually tells me that those adjudicators would like to do more or help others, but often their hands are tied because of policy or the legislation. But today we are focusing on the positive. After all, this is all about what worked. Moving on to the next argument. Impaired by drug. Now, as I said before, I am not going into detail on this, but a few little points. If you were given a notice of administrative penalty for impaired by drug, do not plead guilty. However, you probably should get a lawyer on that one. These arguments are going to get a little complicated, but I do remember who I'm speaking to. The do-it-yourselfer, the lawyer/student, the morbidly curious. Here are some cases to get you started. Don't say I didn't warn you. Bischler, B-I-S-C-H-L-E-R, where there was a problem with evidence during the drug recognition expert's examination. Also see Rudrum, R-U-D-R-U-M, where there was no information regarding the significance of missing the heel-to-toe step twice. Gill, where there was a suspicion of impairment by cannabis, but cannabis wasn't found in the blood. They did find oxycodone, benzoyl-kegognine, whatever that is. It wasn't supposed to be there and isn't good. But neither have limits under blood drug concentration regulations, and there were no indicia of impairment. Also see McLean, M-C-L-E-A-N, where the constable administering the SFST was not a drug recognition expert. I could go on, but suffice to say, this is a really fun area. Please call me. I love these cases. But if you want to do it yourself, fine. Deprive me of the fun of running that. The next category is one of the biggest ones. This is where you will find the majority of your arguments. Incomplete notice or records. And there are some subcategories that come under this heading. Once we have finished talking about this, I know you are going to look at that disclosure on the portal differently. After all, if you don't know what should be there, how do you know that it's missing? That is what we're giving you today. The legal eyes you needed to spot those arguments. Get ready, here we go. In Lashock, the notice of administrative penalty did not specify an offense. We won a case called Henderson on that issue as well. Now that is a very specific situation, very particular. And if I didn't tell you about it, you might not have noticed it. But in a case like Chinsvende, C-H-I-N-Z-V-E-N-D-E, it should have been obvious. There was no notes, no report, no narrative. Even most of APIS was blank. APIS is the Safe Roads portal. And if you think that was a one-off, no, the same thing happened in Borshowa and Miller and Zever Inc. It makes one wonder how lazy some officers can be. I often say, it's almost like there's a contest out there. How low can we go? How low can we go? How little can they put up on the portal and still have the adjudicator say, it's okay? Well, in those cases, it wasn't okay. But like I say, those should have been obvious. The next winning argument, though, is maybe not that easy to identify without a good set of legal eyes. SCHRAM, SCHRAM, there were no DRE records, DRE drug recognition expert. Or it can be as simple as no NAP was uploaded onto the portal. And you might miss this one because if you're the do-it-yourselfer type and you actually got the NAP, you're thinking to yourself, well, I got it. I don't necessarily need to see it again on a portal. But you do. And that was an argument that won in Ray, W-R-A-Y. You see, you want to make sure that the NAP you got actually matches the NAP that they have on the portal. The adjudicator has to see what the NAP says. So if there is no NAP, you win. Another whole category under this issue are calibration and maintenance documents. Like in Merrill, there were 3 screening devices used, but only 2 pictures uploaded. Similarly in Veilleux, V-E-I-L-L-E-U-X, where there was 1 photo of the screening device that was missing. Wilmot was one of those cases where it seemed like everything went wrong. There were error messages with the screening device. They said it was too cold. The officer didn't know what that was. Actually, the screening devices are set up to only operate within certain temperatures. And if you've been in Alberta, especially lately, because I'm recording this in the middle of winter, in the middle of a deep freeze where it was minus 38 yesterday night, well, it can get darn cold. These screening devices were not made to be used under those temperatures. Another error message that they got in Wilmot said that the person's blood alcohol level was quite literally off the charts, high. That really is an error message that you can get on a screening device. Receiving that message supposedly means that the person's blood alcohol level was 400 milligrams % or above. Just so you know, death can happen at 350 and is almost certain at 500, and Mr. Wilmot was not dead when the officers were dealing with him. Quite the opposite. The officer actually said that Mr. Wilmot was showing very few symptoms of impairment, and thankfully the adjudicator found all of this somewhat suspicious. Maybe, just maybe, that screening device was not reliable. Adjudicator Gill was also very concerned in that case that there were no calibration and maintenance records for the 4 screening devices used. Here's a subtle one, Oneski, O-N-E-S-K-I, where, there were tags for the screening devices and they showed instructions, but did not show the annual maintenance or calibration dates, and there was no note about the serial number in the police officer's notes. Now, if you really want to get very tricky, you're looking at the APIS portal. It looks like everything's there. But were the details on APIS, was the report, etc., were they all uploaded and authored by the officer who issued the NAP? Check those names, because sometimes it's another officer who wrote and uploaded everything, and it has to be the officer who issued the NAP. And that is an argument that has won multiple times, like in Young and Bissell and Vole. Again, all citations are at the end. Now, if you look at the screening device photos and you think, I can't quite make out what is written on there. Is that 2021? Is that 2022, etc.? Well, you're not alone. Where information on the screening device tags is illegible, that can be your winning ticket. Just ask Stewart or Scherger or Grattan or all the others who won their appeals on that basis. Say you go to open the screening device photos and it's not working for you. And you think, this must be my error. I'm not very tech savvy. This must be my problem. No, don't assume the problem is you. And do not bug Safe Roads about this issue. Don't go sending them an email that alerts them to the problem when you have the key to quashing the nap. Where the file for the photos was corrupted and even the adjudicators can't get it open, well, that's where the adjudicators bang their imaginary gavels and cancel the nap. That is exactly what the adjudicators did, maybe minus the gavel banging, in St. Germain and Chehayab and Crystal. If you are able to open the photos and the photos that are supposed to be are all there, check them over carefully. If there's any calibration information missing, like in DEOL, you may end up doing a victory dance. And if you think your eyes are deceiving you and you're looking at the two pictures of the screening devices and they look the same, well, you're not alone. Sometimes officers upload two pictures but of the same device, as in Graph. And that's not the only one. See Duiker and others. Hey, no judging. How would you pronounce Duiker? I have roughly 3 pages, single-spaced, all under this category, so we can't go through everything. But suffice to say, look carefully to see if you got everything you should be getting. And if you did seem to get everything you were supposed to get, can you read it? Can you make it out? Is it actually complete? Does it have all the information in it? Those are questions you have to ask yourself as you go through it. Next stop on this lovely legal trip: lack of impairment. A very interesting case that our office won was Hansen, where the appellant was diabetic, and we produced a study to show that the symptoms of impairment could actually have been signs of diabetic issues. The NAP was issued solely on the basis of impairment, but she had failed the screening device. One of our lawyers argued that the fail was tainted by high blood sugar, and we won. I also really liked the reasoning in Borthwick. This was a case where the adjudicator found as follows. While it is possible that an E29 error means that the sample was out of range, did you too start thinking about poor Mr. Not Dead Wilmot, whose blood alcohol level was apparently off the charts but he was showing no symptoms of impairment? You're right, same error message. It is astonishing how many people are just wandering around looking fine while, according to these very reliable screening devices, they have lethal amounts of alcohol in their system. Oops, got a little sidetracked. Back to Borthwick. The adjudicator had said, while it is possible that an E29 error means that the sample was out of range, Adjudicator O'Meara went on to say that I have no basis to conclude that any error on an ASD can be equated to a fail. He had reviewed the ASD manual. It did not state what an E29 error message was or how it should be understood, but the manual in the technical materials library did say at page 13 that any error message other than E06, E09, E10, 11, or 12, impressive list of error messages, doesn't really build confidence though. If those come up, authorized service personnel should be contacted. And therefore, based on the manual, Adjudicator O'Meara found there was nothing to support the issuance of a penalty on the basis of an error message. Phew, that's good news. Another important case by Adjudicator Gill. See, it's not always O'Meara. Adjudicator Gill found in Glover, Glover, that he was not going to put a lot of weight on the police evidence because, yes, they got a fail, but he was quite convinced it was contaminated by mouth alcohol, especially because the person was showing very few symptoms of impairment. And watch out for the cases where there was no test done. These are where the officer just assumed, "Yup, looks impaired to me." And in the end, it didn't look like impairment to the adjudicator because there were insufficient indicia of impairment, like slurred speech, balance and coordination issues, red, glossy, bloodshot eyes, difficulty with comprehension, slurring of speech, odor of alcohol, driving pattern. Those are the factors that point to impairment, and the absence of them is what you're going to argue. That was how the drivers won in Murray and in Ogbazgi, Ogbazghi. And in case it needs repeating, I do love impaired by drug cases. Kim is a good example why. This was a case where Mr. Kim, or Ms. Kim, I can't remember which it is, the person Kim was given a nap for impairment by drug. There had been an accident, and cannabis was found in the Kim's body. Adjudicator Nowak found that she was not satisfied that the recipient was impaired to any degree by drug at the time of operating the motor vehicle. The lab report verified that the Kim had at some point consumed cannabis, but without an established level or amount found within the body, Adjudicator Nowak could not find that that alone proved the recipient was impaired. Nicely reasoned, Adjudicator Nowak. The next category we have kind of touched on already, but it's the maintenance or calibration of the screening device. And on that issue, if you find that the calibration and maintenance documents were not provided, that can be a standalone argument, and you can see that some of these arguments overlap. That's okay. But look at Davies, Davies, or Textor, Textor, for some cases to get you started in this area. One of my favorite areas to argue is reasonable excuse for failing or refusing to comply with the demand. The case that really gets me going is Hodel, Hoedel, where the recipient of the nap initially refused, then they got legal advice, and then they offered to provide a sample. See, lawyers do things for you. The officer said, it's too late, even though the nap had not been issued at that time, and it had only been 4 minutes since the person changed their mind. The decision at the end was not solely on the basis, or even really on the basis of legal advice, but it does illustrate what legal advice can do. Sometimes people have medical conditions which make it difficult to provide a sample, like in Dieta or Oyatoro. A case that almost makes me laugh is Horobin, Horobin, where the person was too intoxicated to know that a demand was even made, and therefore did not fail to comply, which was the basis of the nap. What I like about that case, especially for you as you're listening, is sometimes things appear obvious. If someone's slurring their speech and they've had a terrible driving pattern, etc., that's going to be the first thing you see. But what was the basis of the nap? If it was impairment, okay, you're in trouble. But if it was only failure to comply, skip over all the stuff about impairment. We really don't care. Was there any proof of failing to comply? And this segues very well into our next category. And at this point, I'm kind of hoping you're sighing to yourself thinking, gosh, there are a lot of categories of how to win. Yes, there are. Next category. The person did not fail or refuse to comply with a demand. Now you may be asking yourself, wait a minute, how is that different from what we just talked about? If a person had a reasonable excuse for failing or refusing to comply, isn't it the same as not failing and refusing to comply? Kind of. I kind of think that the difference between them is subtle, but one way of looking at it is this. The category we just looked at is predicated on there was a failure or refusal, but there was a reason. Here, we're arguing there was no failure or refusal. So look to see whether the officer gave good enough instructions and whether or not the recipient of the nap was really trying. Adjudicator Gregory found that the officer in Gautier was not giving good enough instructions and the recipient of the nap was trying. Another very helpful case is Vega. Yes, it's repeated twice, Vega. I'll give you the citation later. But there, Adjudicator Leadham found language issues. The recipient of the nap spoke Spanish, and did not understand why the officer stopped him or was allowing him to try to provide samples, and the officer did actually say that the recipient appeared confused at times, and so the adjudicator found there was not a reasonable opportunity provided. Language issues can offer a lot of arguments. I both love and hate the decision in Roe, R-O-W-E. And actually, I should specify, the decision is fine. The circumstances are shocking. The officers were not honest. What I love about it is that the recipient was able to prove it with a doorbell. The recipient used the audio and video from her doorbell, showing that although she initially did not want to do the test, after the police officer said, "This is your last chance," she said she would do the stupid test. But they arrested her, and again, she said she would do it. But the officers said she had just said no. Adjudicator Chulo saw through that, mainly because there was the audio and video from the doorbell. Kind of hard to believe the officers when the audio and video recordings show the exact opposite. Moral of the story? Buy yourself a good doorbell. Adjudicator Koski in Buenher was faced with a 71-year-old who had cognitive impairment issues, had suffered a fall, had COPD, and she also found that the Buenher, I forget if it was a male or female, was not given a reasonable opportunity by the officer who wanted to hurry things along. A few other little gems, Tejada and Williamson, are good lessons for us too. The NAP in Tejada was issued for refusal, but the officer had noted that the person failed the screening device test. And frankly, if you thought that was just a one-off stupid officer, well, it happened again in Williamson. And although I mention stupid officers quite often because that's normally where your best arguments come up, I will pause at this moment to say there are lots of very good officers out there. But these aren't the ones we're usually highlighting in these cases. I like the case of Bridges, B-R-Y-D-G-E-S, where Adjudicator Williams found that the officer did not give a reasonable opportunity to the appellant to comply. Now, that appellant had asked to speak to a lawyer first. The officer said, "Right to counsel is suspended during screening," and would have arrested if there was no compliance. After the request for the lawyer, the person, Mr. Bridges, was arrested for refusal, and Adjudicator Williams noted that the narrative was sparse, 3 sentences, how low can you go? And there were some conflicts in the evidence, and she found that the appellant was just asking a question and did not actually fail or refuse. Thank you, Adjudicator Williams, for believing the appellant. I'm going to move on to this very interesting category where the person drank after driving and there was no expectation that a breath sample would be required. The case of Zuck is a fun one, Z-U-K, where Mr. Zuck originally planned to stay at his ex-partner's house. Maybe not the best plan. It gets worse. While at his ex's house, he discovered, awkwardly, that the new boyfriend was already staying there. That drove the recipient to start drinking in his vehicle. Poor guy. He requested a ride home from the ex-partner. Again, awkward. Gave her the keys, but the new partner would not let them drive the recipient home. Go figure. The recipient testified that when the ex-partner said she would not drive him home, he planned to ask neighbors for a ride home. Now, why didn't he think of that at the beginning? The reasoning was definitely convoluted, but at the end of the day, the adjudicator was satisfied that any drinking had taken place after driving, and he wasn't planning on driving, regardless of some of the more questionable decisions he made. If the basis of the NAP was blowing over the legal limit, you normally have to show that you weren't over the legal limit, and one of the ways you can do that is show that there was potentially mouth alcohol present, like in Heinecker, H-I-N-E-C-K-E-R, or Davenport. And there you have it. That concludes our review of the cases. Hopefully at this point, if you go back to the portal and you look at that disclosure, you're going to look at it differently, more critically. I am also hoping that now you have more confidence in going ahead with your IRS review. Or maybe, after all of this, you've said, to heck with that noise, I'm calling a lawyer. In which case, call me, because as you can tell, I really like this stuff. Thank you for joining me today. The next podcast is going to be how to choose your lawyer and how to ensure that they choose you as a client. It's going to be about that special relationship between lawyers and their clients. Shannon Gunn Emery signing off for now. Yes, you are right. We are not completely done. The citations are coming up right after the music. Congratulations, you are officially a keener. Welcome to the club. I'm a keener too. Now, when you cite the cases, when they're from the Alberta Safe Roads adjudicators, they have a standard format. There is the name of the case, then in brackets, RE, R-E, then a comma, then the year, ABSRA, and then a number. Nearly all of the cases that I am going to cite are from 2022. If they are not, I will say it's from 2021. There are practically no cases from 2020 because the regime only came into being in December of that year. So when I'm listing off cases and I say something like Smith 1905, that is completely made up. Don't write that down. That means when you're citing it, you would say Smith, round bracket, RE, closed round bracket, comma, 2022 ABSRA 1905. The cases from the Court of King's Bench are a little different, and I will give you the full citation for those. So here is the list. Top of the list from the Court of King's Bench, Dorn versus Alberta, Director of Safe Roads, 2022 ABQB 394. That was on the report of the officer. And now for the Safe Roads cases. Pigeon, PIDGEON 1133, Burke, BURKE 1179, Auger, AUGER 676, Hunter 769, Kumar, KUMAR 1330, Kyrgyzstan, KRZ YS ZTAN 898, Provost 560, Pearson 2021, and that's not the year, that is the number, Lumley LUMLEY 794, Smigelski 829, Charpentier CHARPENTIER 854, Holsworth HOLSWORTH 574, Pristay PRYSTAY, a 2021 decision 354, Ferguson 1165, Finn FINN 1355, Isidore is a 2021 decision 346, Bischler BISCHLER 1229, Rudrum RUDRUM like Michael 1368, Gill, a 2021 decision 52, McLean, another 21 decision 62, Lashock LASHOCK 1567, Henderson 1022, Chisvende CHIZVENDE 1254, Borshowa BORSHOWA 1402. If I'm reading my writing right, I double-checked just for you, and yes, it's 1402. Miller 1399, Zeverink ZIEVERINK 1354, Schramm SCHRAM 1163, Ray, W-R-A-Y, 1283, Merrill, M-E-R-R-I-L-L, 1101, Veilleux, V-E-I-L-L-E-U-X, 1227, Wilmot, W-I-L-M-O-T, M like Michael, O-T, 511, Young, 977, Bissell, B-I-S-S-E-L-L, 719, Voll, V-O-L-L, 2010, that's not the year, that is actually the number, Steward, S-T-E-W-A-R-D, 926, Sugar, and no, it's not sugar, it's Sugar, S-C-H-E-R-G-E-R, 697, Gratton, G-R-A-T-T-O-N, 562, Saint Germain, S-T period, G-E-R-M-A-I-N. It's going to be easiest to find that one by using the citation 2022 ABSRA 1005, and then that case will just pop up, and use that in the citation box. On Canley, Chehayeb, oh boy, C-H-E-H-A-Y-E-B 841, Crystal, K-R-Y-S-T-A-L 643, Deol, D-E-O-L 913, Graf, G-R-A-F-F 857, Duiker, D-U-I-K-E-R 732, Hanson, H-A-N-S-O-N, a 2021 decision 236, Borthwick, B-O-R-T-H-W-I-C-K 1302, Glover, G-L-O-V-E-R 1166, Murray, M-U-R-R-A-Y 650, Ogbazgi, you're so lucky I spell these things for you, O-G-B-A-Z-G-H-I 856, Kim, K-I-M 709, Davies 547, Textor, T-E-X-T-O-R 672, Hodel, H-O-E-D-E-L 1383, Dieta, D-I-E-T-A 627, Oyetoro, O-Y-E-T-O-R-O 770, Horobin, H-O-R-O-B-I-N, it's a 2021 decision, 10, must have been right at the outset of 2021, Gautier, G-A-U-T-H-I-E-R 1548, Vega 1602, Rowe, R-O-W-E 1363, Buener, B-U-E-N, like Norman, H-E-R 1299, Tejada, T-E-J-A-D-A 828, Williamson 1116, Bridges, B-R-Y-D-G-E-S 820, Zuck, Z-U-K, that's a 2021 case 496, Heinecker, H-I-N like Norman, E-C-K-E-R 1340, we're almost at the end, Davenport, D-A-V-E-N-P-O-R-T 658, Couslan, C-O-U-E-S-L-A-N 1275, and the last one, Swiston, S-W-Y-S-T-U-N 1057. So, if you ever thought your lawyer was just making up stuff, no. As you have seen, there are lots of cases where people are winning, and those cases are what we use to help you win yours. Talk to you soon.